I'm the vice chair who will be conducting the meeting today, Mike Gervais. To my left, member Russell Chin. Already. John Himmel, and Jerry Franklin. Good job. We do have special services, our clerk, Ms. Murphy. If you have any device that makes noise, like a telephone, just turn it off. You gotta speak to each other. You can go outside and do that because it gets a little noisy here sometimes. If you're gonna testify, which means come up here and speak at all, I'd like you all to stand up. If you're gonna testify, raise your right hand, I'm gonna swear you in.
Now.
Anybody gonna talk? If you're gonna talk, please stand up.
That's better. You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you. We have only 4 members tonight. We only have 4 members tonight. And if anybody, we usually have 5. We just made a quorum. And in order to proceed, you have to get all 4 of our votes today. So it's a kind of a higher standard because there's only 4 of us. And anybody would like to postpone their hearing to the next time when we should have 5 people, you can do that. And you'll be,
It could be 4 to 1 vote.
yeah, there could be a 4 to 1 vote and your motion, your case would pass. But right now, if one of us disagrees with the other, you're out. So if anybody wants to do that, stand up and tell me now. And you'll be up the next, 2 weeks from now. Everybody okay? We're gonna go forward then. All right. Mr. Chair, can I would have a motion to waive the readings of the minutes of the meeting on March 25th?
Yeah, Mr. Chairman, I make the motion that the minutes of the meeting from March 25th, 2017 be
Wait. Or wait for the reading.
waived. Reading be waived.
Second?
All motion seeing none, all in favor?
Aye.
Let's have it. Matter number Z, 17-32, Kevin Chan for a variance to construct a second-floor addition to create a 2-family home on the premises numbered 26 Station Street in Quincy. Is the applicant or the representative here?
Yes.
Please come up, step forward and state your name and address for the record.
My name is Kevin Chen.
That's not the record, you'll be talking to us. You'll talk to us.
Okay.
Yes.
My name is Kevin Chen, and my address,
Yes.
current address is 50 Brandon Street, Quincy, Massachusetts,
Okay.
02170.
Okay. Go on. What do you want to do there?
We would like to do a second floor addition to create a 2-family, so my father and my mother can live on the first floor. My wife, me, and my 2 children can live on the second floor.
So in other words, you want to make this a 2-family house,
Yes.
and it's a 1-family house now.
Yes. It is located in a residential B zone.
Okay. You want to go over the plans a little bit, so you, like for example,
Yes.
talk to us about where your drawers are going to be, how you're going to get in and out of the place, stuff like that.
Okay.
Yeah.
So the first floor is going to be a 2-bedroom plus a playroom, dining room, kitchen, on one full bar. Is that good? Okay, the second floor is going to be the same thing, and plus the second floor has an attic that's considering 2 more bedroom and a bathroom.
Okay. Anything else you want the board to know?
We have the existing house. We have 2 driveways, so we have enough parking, and we are not to do anything like inside. We are not adding anything in the rear, and not anything in the front, not anything on the side. So we're just going up. In the current rear setback, we comply. The front is we stay as is. Right now it's a 10.1. On the left-hand side, we have existing 12.3, zoning required 13. On the right-hand side, we have 21 and 0.45, zoning also required 13.
Okay. So in other words, you're really just literally just going up.
Yes. Existing is a 1.5, we're going to a 2.5. I have some pictures to show for the surrounding houses. This is the current house.
So these are the houses.
It shows like the surrounding houses, they are all like 2 and 2.5 story. We are the only house in the street that's a 1.5 story. And it would make the street like look better to have all the houses like almost uniform instead of one that's like so old and stuff.
Any questions of the board?
I do. Mr. Chan, what side of the house has your parking? Does it face the house?
There's driveway on both sides.
So you
The
have
right
two
side, yeah, the right side also have a garage.
So a total of how many spaces do you have off street?
Off street we have like 6, but it's 10 and 3 on each side. It can accommodate for like 6 cars plus the garage.
Okay.
And we only require 4 for according to zoning, 2 per unit.
I think it's okay. Mr. Hummel? Okay, thank you. Mr. Franco?
Couple questions, sir.
Okay.
Who lives in the house right now?
We just bought it like
Bought
a few months ago. It has been vacant and we are trying to do the plan and the renovation.
And
Right now
who
it's
do
vacant.
you anticipate living there?
It's our whole family. My father, my mom, me, my wife, my
You
two
see,
kids.
you're putting in 6 bedrooms, so
Yeah.
let's see who's gonna be there. All right, so, and how many people are driving?
It's my wife, me, and my dad.
So, 3 cars? Don't have to worry about the 2.5 and the 1.5-year-old for a while.
No, not yet.
How wide is the driveway?
The driveway is for a single car, but it has like green space on both sides. But we have 2 driveway.
I don't have anything else, thank you.
Thank you. You can have a seat.
Okay.
Anybody would like to speak in favor of the project? Once, twice, 3 times, but part of the hearing closed. We have a letter from DPW that says they have reviewed the submittal and they have no comments. Anybody opposed or undecided? Opposed or undecided? Once, twice, 3 times, but that part of the hearing closed. Gentlemen, what do we think? I think, and looking at the neighborhood, that this would not be such a terrible thing, actually, because the old bigger house, and because it's like everything else in Quincy, small streets and all that. But I might tend to be in favor unless you guys think otherwise.
I'm in favor.
I'm in favor also.
He used to play
Can you come back
golf in
up,
college,
please?
so that's,
Where'd our guy go? Could you come back up, please?
Yeah, sure.
You're redoing the entire outside of the house
Yes.
after you do the renovation?
Yes, a new siding, new windows, new roof.
What are you using for siding?
It's probably gonna be vinyl because that's what they have on the whole street. I can show you a better picture on my iPad because my printer is just black and white, you know.
show us on the idea.
Okay. Like this is like the house next door.
Yeah.
If you like go left and right, you see like, you know.
Well, we want to know what you want to do though.
Which house are you gonna,
Which house?
I mean, are you gonna use the same vinyl siding as everything?
Yes, same.
Which house will that?
We probably going with this style, but not this color. Maybe something like dark green or something. That's what I always want, you know.
House needs a facelift, the plan
Yes.
is nice, I'm in favor.
Okay, we can have a motion.
Mr. Chairman, in case number Z17-32, Kevin Chan. for a variance to construct a second floor addition to create a two-family home on the premises number 26 Station Street, Quincy. I make a motion that the application be allowed.
Second?
On the motion, seeing none, all in favor?
Aye.
Ayes have it. Thank you. You're set to go. Thank you.
Thank you.
Case number Z17-33. Paul Chanette, trustee of the P&D Realty Trust, for the appeal of the inability to receive enforcement of the premises number 210, 216 Washington Street, Quincy. Is there an applicant or representative here? Hello, Mr. Ritchie, if you just say your name and address for the record.
Good evening. If I could just, I know Mr. Schnett's outside, everybody in if I could. I will introduce myself. My name is Attorney Joseph McRitchie. I'm representing Mr. Paul Chanette, who's the trustee of the P&D Realty Trust, and he owns property located at 202 through 208 Washington Street in Quincy. And this is an appeal of the inability to get zoning enforcement under the provisions of Chapter 48, Section 7. We did write a letter to the the Director of Inspectional Services and pointing out 7 specific instances where we felt that the zoning was being violated in the abutting property. It's located at 210 to 216 Washington Street, which is owned by DeBona Realty LLC, of which Mr. Mark DeBona is the registered agent. And to give a little bit of background, the property is, located on the property is Cagney's Restaurant, right down here in the Quincy Point area, just outside the square. MDB Inc. Does business as Cagney's, and Mark DeBona is the sole officer and director of the corporation. Also on the property, since this appeal was filed, there's been a new license issued for a new bar and a new restaurant to be called the Poor Yard, owned by RAC 208 Inc., of which Mr. DeBona is also the sole officer and director of that corporation. There's also, it's a mixed-use property, and there are a residential apartment upstairs on the second floor. The real property, the real estate lot on which the property sits was established in 2012 with the filing of a, under the subdivision control law, a plan indicating that subdivision control law does not apply. That's commonly referred to as an approval not required, or an A&R plan, or a Form 1 plan. Was filed in the Registry of Deeds, and Mr. DeBona bought the front properties. They were carved off from a larger parcel of land that goes down Raymond Street and is occupied by, I'll call them the Republic entities. I believe it's Republic Plumbing Supply. They've got a warehouse, they've got a parking lot. Originally, this was part of a larger parcel that exceeded 14,000 square feet. The part that was carved off with the A&R plan is slightly over 6,000 feet. And on the plan itself, it identifies 2 lots, but they're held in common ownership. Both lots are less than the minimum size required under the zoning. But under the theory of merger, since they're held in common ownership, they are merged as a matter of law, and it is a lot that does exceed the 5,000 minimum size lot that's required. But the note that I would like the board to take note of is on the plan itself that was submitted to the planning board, and it has the approval not required plan, the approval not required language that's required on the plan, but it also notes that there's restrictive endorsements on the plan above the planning director's signature, and that the 3 restrictive endorsements read as follows. Lots are created for conveyancing purposes only. That's note number 1. Note number 2, no determination of wetlands has been made or intended by the planning board endorsement. And the most interesting one is note number 3, no determination as to compliance with zoning ordinance requirements has been made or intended by planning board endorsement. In 35 years of practicing law and looking at lots of A&R plans, I've never seen one that says right on the face, we're not saying this complies with the zoning ordinance. And I think it's obvious why. From my perspective, it doesn't comply with the zoning ordinance. So I wrote a letter to the, and I do want to back up just a little bit. The date of that plan is December 2011, and it was recorded in the Registry of Deeds, or not the Registry of Deeds, it was recorded in the Land Court Department of Norfolk County, which is registered land, early in January 2012. That's important because the City of Quincy zoning ordinance that's currently used was adopted in June 22nd, 2011. So when this lot was created, it was subject to the current zoning ordinance that's in effect. So, you know, you may hear during the presentation by counsel for Mr. Zabona, you may hear, and Mr. Duca may even talk about pre-existing, non-conforming, and so forth. The lot was created after the adoption of the current zoning ordinance, and I think that's very, very important in this case. Now, again, I did write a letter to Mr. Duca, and I was requesting that there be zoning enforcement, and I did note 7 specific violations of the zoning ordinance. And my original letter is attached, appended to, and incorporated into the appeal that's before the board. And I just want to go through them very quickly. The current zoning ordinance for Business B, and this is a Business B zone, it's a mixed-use building, and it includes apartments. And the minimum lot size for residential uses in a Business B zone is 14,000 square feet. This is a 6,000 square foot lot. Prior to the approval not required plan and the conveyance from the prior owner, this was part of a lot that exceeded 14,000 square feet. So it was a legal sized lot that in a Business B that had residential uses. It's been conveyed off. 6,000 foot lot, an undersized lot. There's never been any application made to this board. It was conveyed at the time, the minimum lot size is 14,000 square feet. It didn't comply when it was conveyed out. Mr. DeBona took ownership of it, or the DeBona Realty LLC, Limited Liability Corporation, took ownership of it, and it's an undersized lot. And I've cited the section, and that's the first violation that I cited in my letter. Cagney, as it's currently operated, the second issue that I raised, fails to meet the definition of restaurant local that's contained within the zoning ordinance. And I quoted the language, and it's on, it's under the number 2 in my discussion or my letter to Mr. Duca. And the definition of restaurant local is eating places of 5,000 square feet or less of gross floor area per establishment, primarily serving local needs, but not limited to lunchroom, restaurant, cafeteria, place of sale, consumption of beverages, ice cream, etc. Important phrase. Primarily in enclosed structures, with no dances or entertainment other than music, and no drive-in or retail or drive-through window service. And I've added the emphasis and underlined primarily in enclosed structures, because the operation of Cagney's at the time this application was filed included a 98-seat restaurant indoors and an outside patio. And that's what this appeal is really about, is the outside patio. It was built last fall. It was called the Courtyard at Cagney's. Since this appeal's been filed, they're changing the name, they're reconfiguring things, but it's a outdoor patio with 50 seats. Now, I'm not sure that a primarily indoor seating, 1/3 of the seats are outside and 2/3 of the seats are inside. I'm not sure that meets the definition of primary, but I think that argument goes out the window with the new restaurant that has since been approved by the licensing board, 23 seats inside and 50 seats outside. So we have 2/3 of the seating is outside. This is not primarily indoor dining. So it doesn't even meet the definition of a restaurant local as that term is defined by the zoning ordinance.
Mr. J, you just get lost again. I'm sorry. Let me interrupt you, guys, I do.
Please ask the question, I'd be glad to.
From what you just said, it sounds to me that Cagney's is operating primarily in enclosed structures.
Well, I don't know whether a third of the seats outside on the patio is primarily.
I was
That's,
at
that's,
51.
that's a good
Okay,
argument.
right.
That's the point. That's an issue that certainly can be debated. But with the new restaurant, 23 seats inside and 50 seats outside, the ratio has been flipped. Instead of 1/3, it's now 2/3 of the seating is outside.
So you would have us separate, they're separating two restaurants, is that what you're trying to do?
There's been a second restaurant licensed. On the other side, we'll get to that too, but the second restaurant called the Poor House, Poor Yard, 23 seats. What was operated there prior to that was called the Quincy Cafe, a breakfast, coffee shop type place, licensed by the licensing board, common victuals license, seating of four people. Now it's been expanded to 23 people with 50 seats outside. So a licensed premise of 4 has now been expanded to 73. I think that's a substantial expansion of a non-conforming use at the very least that has to come before this board. Substantial increase of the non-conforming use. We didn't even get to the part about the no setbacks and so forth yet, but if I'm wrong on every argument I make, at the very least, this is a non-conforming structure, and they're increasing the non-conformance by adding 50 seats, strike that, 69 seats to a 4-seat restaurant. Okay, that's one of my further points, but that's number 6 or 7. I'm still on number 2 here, then please bear with me. I want to talk a little bit about off-street parking. Prior to the conveyance to Mr. DeBona, the prior owner owned a parking lot that was down the street. Now, there's no provision in the lease that I saw. There's nothing in the record of the licensing board that I've seen between the current owner and Cagney's. Going back years, the property was owned by L. Paul Marini, who was a well-known attorney in Quincy and owned it for years. And there's reference to parking being used at that time. But again, we've got the 2011 parking requirements in the zoning ordinance that now cover these new lots that were created. And I want to just quote from section 5.1.2 of the current zoning ordinance that was adopted 6 months before these lots were created. And it talks about off-street parking, and of course the parking requirement is 1 parking space for every 4 seats. So when we're talking about 169 seats, we're talking 42, 43, 44 parking spaces. And in the zoning ordinance, section 5.1.2, ownership or control. Off-street parking facilities shall be under the same ownership or control as the building or buildings for which they serve. Where a certificate of occupancy has been issued conditional on the maintenance of off-street parking facilities, such certificate of occupancy shall lapse in the event of a sale or conveyance of the land used for such parking facilities for the required parking. Subparagraph 1, in the case of control, in parentheses, not ownership, the applicant shall demonstrate that control is conclusive for the period of intended use. Now, there's no parking available for Cagney's, for the Poor House, for the apartment that's upstairs. This building with 169 seats, 40-plus parking spaces required. And this was a lot, again, that was created after the adoption of this ordinance. So this lot was created when this was the requirement. The old requirement talked about 300 feet and you could use somebody else's land and so forth. Here the land has to have control of the parking. They have to control it throughout the ownership of the intended use. And I suggested to Mr. Duker in the letter, the liquor licenses are renewed every year. They should have to come in every year and show this is where our parking is. And I don't think it's good enough to say, oh, well, you know, they can park on the street, they can park on somebody's parking lot after the business closed, they can go over here, they can go over there, they can go in the Little Peach as long as they don't get towed. You know, they don't have parking. It's a requirement of the zoning ordinance, 1 parking space for each 4 seats. And again, we've just had an expansion of the license. We've had an expansion of the license on this property, an additional 20-plus seats with the new restaurant. The patio at Cagney's has now been transferred to the Poor Yard, but you know, since last December, there have been 70, or a total of 73, it's been 69 increase of seats licensed with no parking. And it's requirement. And again, my client lives directly, is in a direct abutter of this, the restaurants and this patio where, you know, 50 people are gonna be out there every night in the summer drinking 5 feet away from the window with the family upstairs. So it is a real burden. You know, again, Cagney's is 98 seats, had the 50 seats on the patio in the Quincy Cafe. That was a total of 152 seats. Now, with the licensing board action of a couple weeks ago, Cagney's 98 seats, the Poor Yard 23 seats, 50 seats on the patio, that's 171 seats. That's 43 parking spaces plus the whatever's required for the upstairs, 1.75 for an apartment. So you round the fractions up and you've got, you know, you've got 45, 46 cars parked in the area with no parking. Next issue that I raised is that the bar is located in the side yard setbacks, open space. You know, this patio had been the side yard. There's a 15-yard setback requirement in the zoning ordinance. And this is a congested area, and I understand it, and my client, whose house was built in the 1920s, prior to the adoption of subdivision control law, he has a very short distance between his building and the lot line, but when the bar is operating outside, outdoors, right up to the lot line, let me just back up a little bit. The open space, the definition of open space on the side yard setback of 15 feet, yard is defined as the open area in the front, side, and rear of a building. And by allowing the bar to operate in that setback requirement, it's supposed to be open space. In effect, we have a license board that's granting variances. And it's this board's responsibility to make sure that the zoning ordinance is complied with. And it's not, I believe it's not. So I think that for that reason, this board needs to instruct the Director of Inspectional Services to take enforcement action. Now, the fifth issue that I raised was the sign. On the back of the back wall of the patio, there was a big sign placed and it said, "Welcome to the courtyard at Cagney's." That sign's come down, the frame's still up. I assume the sign's being redone to say something about the Poor Yard, but I don't think there's any question that this is a sign. The definition of sign in the zoning ordinance, it's extremely broad, and it includes a message designed to be seen from outside a building and visible from a public way, which is used to direct public attention to and or indicate the presence of any product, service, or activity whose purpose is to convey a commercial or a non-commercial message. Now you've got this big sign that's at least 12 feet long and 6 or 8 feet high, and it says, "Welcome to the courtyard at Cagney's," or whatever it's going to say with the new Poor Yard, and it's got, you know, pictures of, you know, whatever, and we do have pictures that we can submit to the board. Mr. Chanette will has some photographs that I think would be very illustrative, but I don't think there's any question that this is a sign. Now, if it's connected, and we haven't climbed over the fence and gone in and examined how the sign is put up, but I raised this with Mr. Duker, and Mr. Duker says, well, it's no violation. If it's a freestanding sign, meaning it's connected to his own property, Mr. DeBona's property, then it's a freestanding sign under the ordinance, and that requires one set of approvals. If it's connected to the building in back, somebody else's property, which is what I believe it is, that's an off-premise sign. It's connected to property owned by somebody else. And an off-premise sign, this board doesn't even have any jurisdiction of. Off-premise signs under the Commonwealth of Massachusetts are regulated by a state agency called the Outdoor Advertising Board, and you have to get a permit. This is in effect, would be a billboard. And this board wouldn't even have jurisdiction to allow it if it's connected to the building in back. But it's certainly not connected to the side of the building, and there's never been any permit issued for it. You know, I don't know how Mr. Duca could say there's no violation. Anybody that puts up a sign in the city of Quincy has to get a permit from the building department. No permit was issued, but yet Mr. Duca says there's no violation. So I really don't understand that, and maybe somebody can explain it to me, but I think it's incumbent upon this board to make sure that the zoning is complied with, whatever type of sign it is. And again, I don't know whether it's a freestanding sign, an off-premise sign. I don't believe it's a building sign that's connected to the building, you know.
Mr. Ricky, hold on, one second. Didn't you also just say that the sign's not there?
The sign's been taken down, the framework is still there.
That's not a sign, it's a framework. So you're
Well,
asking us to
Okay,
take down
so when
something we did
you took it down because it's no longer, well, let me put it this way too. The sign ordinance says if it relates to a business that's no longer conducted, it's supposed to come down within 30 days. Now, it was Cagney's, and the license board transferred it from Cagney's to the poorhouse, which hasn't even opened yet. So, under the ordinance, he's required to take it down, but Mr. Duca says it's not even a sign. You know, but if the sign goes back up, which I expect it is,
That's something else.
okay, so I'm gonna have to go and start over again with a letter to Mr., you know, the question is, we'll have photographs of the sign, you can decide whether it's a sign, and if it's a sign, the ordinance should be, and if the frame is still standing, and if the frame is connected to the building behind, then it's an off-premise sign. And again, it's, that's up to the Outdoor Advertising Board, but it's a violation of zoning, it's not allowed. Almost done. The next issue is that this is a mixed-use building. We have commercial and residential. Mixed-use building requires a permit from the zoning board of appeals. And again, I talked about the 14,000 square foot minimum for residential uses in a business B zone. This is a 6,000 foot lot, but again, it's residential and commercial. It's a mixed-use building. Clearly in the table uses, it says BA, Board of Appeals. You haven't heard it yet, and it was created, and this building was, you know, on a lot that was created 5 years ago, never come to the board for any approval. The last point that I certainly would like to make is that when the patio was built, it filled in and took away whatever parking there was for this building. This was a driveway that went in. They had a dumpster in there. They had, you know, they got deliveries in there. People could park their cars there. Not a lot of spaces, but it was some spaces. Maybe it wasn't lined off, but there's area to park on the property. That's been taken away. So they've made it more non-conforming by taking those parking spaces away. You know, maybe those were only enough spaces for the apartment to meet the apartment requirements upstairs. But still, you know, that was parking. It's been taken away. This property has become more non-conforming through those actions, and the zoning board should take some action on that. That pretty much completes my presentation. And Mr. Chanette, who is a landlord, and he does have a mixed-use building, and it is pre-existing, non-conforming. It was built prior to and has been used continuously for both commercial and residential uses since before the subdivision control law was operating in Quincy. He has tenants upstairs, and he can talk, and he'd like to talk about the impact that this 50-seat bar room, 3 feet from his tenant's windows, directly below, it's as close as this hip wall here, you know, the bedroom window of a 13-year-old boy who is attending school, and It has to put up with swinging lights and, you know, the noise from a bar right outside his window. And Mr. Jeanette starts losing tenants and is not able to fill the apartment, he's gonna have certainly substantial financial losses. So, you know, he would like to talk a little bit about the impact that it has on his, but I have spoken about the legal issues. If anybody has questions, I'd be glad to answer them.
I've already interrupted you a couple of times, so.
No questions.
Great, well, thank you.
Thank you. Okay. Sir, just give me your name and address for the record.
Oh, sure. Paul Jeanette. And my address is 14 Mayfield Road. I'm the owner of 202, 206 Washington Street.
Thank you.
Sure. Some of these pictures will kind of define what Richie just spoke about. Some of them, issues I have. This first picture defines my building to a certain degree. And if you notice, there's a driveway beside it. The window on the top is a living room window. The window on the bottom is a bedroom window. And there's other windows that really are viewable on this way. With this trip to the site, they could define a little better. This is the driveway, this picture that was filled in to build this patio. And you'll see that there's a dumpster also there, which has been removed. This picture is the sign that he was referring to. It was up all winter. And I might add that that sign, the lights were lit a good part of the winter, infringing upon my tenants.
Is that the same as this?
No, that's my face page, inviting everybody to a beer fest.
Oh,
But this actually is probably very similar. This was one of his festivities he had at that site. So you can see the sign is across a building owned by Republic Plumbing Supply. The original plan shows a dumpster. This was what was filed. And it shows half that area being used for the courtyard. And that's not the case if you take a look at it. As you can see by this one, it shows his tenants parking. That's his tenant parking in that driveway, which has been removed. This is the first night that he was allowed to operate the establishment. He got a special permit to enter. And when I arrived, that's what my tenants were seeing. That's the lights, that's the view from my porch, which, if you look at that fence, there's a gutter there. That's how far that fence is from the gutter. And below, there's a trench that's 6 inches from my wall. And I asked him when he started this, he never told me that he was putting in the patio, or he was putting in 50 seats. He was gonna redo the driveway. So this will give you sort of an altitude of how much was filled in. And that's a before picture, before they filled it in. And then there's an after picture right here showing the same view. And that shows the second means of egress, by the way, right in front of you. I hope I'm not going too fast. If you have any questions at all, please feel free. This isn't something I do every day. And here's the coffee shop that was converted to, that's being converted to the
You
courtyard.
said it had 4 seats? You had 4 seats?
4 seats in one, yes.
Oh, that worked.
And before that was a coffee shop, I might add. That was never a restaurant, and that was only a couple of years ago. That was a check cashing place, and a place where they sent money back home to Brazil, etc. And there's a frontal view of the restaurant, which shows Cagney's and shows a coffee shop in between. And it shows how it's not contiguous with that, the original patio. If there's any questions on those pictures, I'd be happy to enlighten you. But my story is I've owned that building. I've been in business for 41 years in the city. I bought another company that was 49 years old, so we got 90 years in this city. Marina Salinas lives on the first floor. Christopher Lazinski lives on the second floor. And Dodi Kaka and his 13-year-old son also live on the second floor. That's less than 5 feet away from this proposed patio for 49 people. These residents have to get up, go to work, go to school most days. They try not open the spot till 11 o'clock at night. The outside bar is sandwiched between 3 buildings, reverberating the noise. The lights, when it's windy, are swaying back and forth. It's a constant light show in the apartments and outside their windows. Penetrates the windows. The lights were left on, as I mentioned previously, a good part of the winter, which gave him a unpermitted lighted sign. I rely on this building for my income. I'm retired, and I don't want to lose any valuable tenants. I have great tenants and they're hard to come by. I don't want to lose them. So my question to you people is, why would the city allow Mr. DeBona's greed to have such a negative effect on my tenants, myself, and the surrounding neighbors? I understand they have a right to a quiet and safe environment. Is there any questions I could answer?
Anybody?
No, not right now, thank you.
Thank you.
Thank you. Does anyone else want to speak? Well, how do I do this? Favor? Mr. Stuka? In favor of?
I'd like to speak, Mr. Chairman. I don't know if maybe the applicant's attorney may want to.
Well, I want to say, if anyone who's in favor of this, anyone who's in favor of this action, come up and speak.
Supporting the appeal.
What is the action?
Supporting the appeal. If anyone wants to speak in support of the appeal, thank you. Please come up and speak once, twice, 3 times.
Wait a minute, I'm
I do have a
confused.
letter from one of the tenants who,
I'm confused on what you're saying. Support of
Mr. Shinet, how's that?
you guys like granting the parking lot to stop. I was at that license board meeting, I don't understand it either. I think for a restaurant to open up, you do need 4, for every 4 seats, you're supposed to have parking. And I don't understand how, you guys should.
Hang on. What we've asked for is anyone who is supporting Mr. Shinet's appeal of the refusal of the inspectional services to issue orders based upon this argument,
Come up and
speak now.
I'm just giving, what if his appeal is heard, if you guys accept his appeal?
We'll get the other side next.
Right, but I mean, I just feel that,
There's also
I don't even know how to speak on this, it's confusing. Okay, I want to throw in my 2 cents, but I'm not sure what you're asking for.
come at the end.
Yeah,
Okay.
you're looking for the other side.
Okay.
Anybody who wants to speak, I'm sorry, anyone who wants to speak in favor now, or opposed to the application by Mr. Charette?
Thank you, Mr. Chairman, members of the board. My name is Edward Fleming. I'm here on behalf of Mark DeBona and DeBona Realty LLC. There's a lot of information being thrown out there, being thrown out to the public and being thrown out to the board, and I think we need to simplify this a little bit before to really understand what's being requested. This, as Mr. Shinet's attorney indicated, and as Mr. Shinet himself indicated, is really about a patio. About a patio that the licensing board approved. A patio that Mr. Shinet and the folks that
The
are here
liquor
tonight,
licensing board approved.
the licensing board
Yes.
approved. There was a public hearing, there was a full hearing, at which time they had an opportunity to be heard, and they're not pleased with what the licensing board decided. So now what they're doing is they are seeking leverage by filing an appeal to this board, raising not only an argument to ask this board to deny the patio expansion, but also to deny everything that operates from this building and has operated from this building since 1924. It's important to understand the history. What you didn't hear is really the history about this property. I thought that there would be a little bit more information about the title to the property going back to 1918, because that's really when this property it needs to be discussed and reviewed. In 1918, there was actually there's a plan on record at the land court that shows that these buildings actually existed on the site back in 1918. These two buildings that are being occupied and discussed tonight, the building at 210 Washington Street and the building at 214 Washington Street, but that's occupied by Cagney's and the new Courtyard restaurant. Back in 1918, and going back 50 years, there was a restaurant that operated from the facility at 214 Washington Street. There was a separate business, several businesses that operated it from 210 Washington Street. And there was an independent and separate business that operated from 8 Raymond Street, which is the third parcel of land. At all times, from 1924 until present, there were 3 distinct businesses being operated from those facilities. And at no point in time was there any parking. There was no parking for any of those facilities back in 1924 or 1918 when these buildings were initially constructed, and nor was there parking at any time during the operation of the restaurant for 50 years at the 214 Washington Street, or during Mr. Devonta's operation of Cagney's since 1990. Mr. Devonta's been there since 1990 and operating this restaurant. So it's important to understand a little bit of the history here, because what is being asked of this board is essentially to shut them down, to shut all of the operations and all of the uses of this property down, and indicate that they're somehow now in violation of the zoning ordinance. It's not simply concentrating on the patio, which is the real contentious issue here. So what I would ask that this board do is really focus on the patio. And has there been appropriate hearings held that gave the public and Mr. Shinet an opportunity to be heard regarding the patio, which was an expansion of the existing restaurant use? And I would suggest that not only did they have one hearing, but they had 2 public hearings on this. One when the patio was constructed for the purpose and use of Cagney's, and then second when the use of the patio was being converted and transferred to the new restaurant use. Because that's the only issue that's really before this board, and they're clouding the issue by raising these other matters. It's my contention that there's no existing violation. All of these businesses that operated from this facility or from these facilities for years, without parking, and the argument that now all of a sudden that parking is needed, even though it never existed before, is not accurate. And it's not fair to present that argument at this stage. So let's focus on the patio. Since I've been involved, which is just briefly, within the last week or so, I reached out to Mr. Shinet's attorney, and I asked about whether or not there would be an opportunity to sit down with them to talk about the ways in which we can mitigate the concerns that Mr. Shinet had. We talked about the idea of installing additional fencing, by deafening certain noise from the area, by eliminating certain music from the venue at times of night. And we were willing to sit down and talk to see if we could come up with some resolution. And the answer that I got was, well, we're not really interested to do that right now. They wanted to move forward with the hearing before you. So my request, I guess, of this board is that we have an opportunity to sit down with Mr. Shinet and his attorney and have that conversation. These matters are not resolved best before bodies of boards. They're best to be resolved by the parties through negotiation and discussion. What I found interesting tonight, and Mr. Devonta was quite upset by the comment that Mr. Shinet made, was that he was unaware of Mr. Devonta's intention to do this. because Mr. Devon told me earlier tonight that he had a conversation with Mr. Shinet prior to constructing the patio and indicated to him at that time of exactly what his intentions were, and Mr. Shinet had indicated to him that he did not see a problem with that. And it was only until after that complaints were raised. So I would, to now try to use this body and to use the zoning as leverage now, again, because they lost in their argument before the licensing board, is really not fair to anybody that has to go through this process. You understand, Mr. Devon has been operating since 1991. He's made substantial improvements to his property as he's been there. The city is quite happy. I know Council DeForest is here to speak in favor of the business that he's operated from that facility for years. He's been a good corporate citizen and giving back to the community. And what he's doing by the creation of this patio is he's trying to live by exactly what the city has requested of a lot of its businesses. As we see in the downtown, the goal of the city was to encourage outside dining in areas where they could, to expand the sidewalks so that businesses could expand their restaurants onto the sidewalk, to encourage outside dining. We did it a number of years ago with the Fowler House restaurant, just recently. Rosafa, which is with the old Alba lunch facility, now has outside dining, all in close proximity to residential properties, but also located within a Business B zoning district. And the focus should be what the zoning is of the underlying zoning is of this particular property, and that's Business B. This area is intended for business use. And the outside dining restaurant concept is really just following what the city's requests have been, to expand these facilities and encourage outside dining. So that's what Mr. Devon has done. So it's really disappointing that even a commercial tenant himself, Mr. Shinet, who's occupied this building as a commercial use, is now trying to prevent another commercial user to utilize his Business B property in the fashion that really was intended for. So I can go through each and every line item on Mr. Shinet's argument. What I'd like to highlight is, he references the A&R plan, saying that the A&R plan somehow changed the whole picture, and that it all of a sudden extinguished all the non-conforming rights that existed on the site. But again, what I'd like to highlight is that each of these properties were noted as separate properties. They were always identified as separate properties by the city of Quincy as 210 Washington Street, 214 Washington Street, and 8 Raymond Street. Furthermore, all of these properties were operated independently of the other, meaning there wasn't one entity, one business that occupied all three of these parcels. They were always operated as separate and distinct businesses. From 1950 until 1990, Brittany's Restaurant occupied 214 Washington Street, independent of the Chinese food restaurant and the convenience store that occupied 210 Washington Street, and independent of the business that occupied 8 Raymond Street in the rear. So the A&R subdivision, or division of the site, didn't change anything. Everything remained the same. It didn't eliminate any parking that previously existed. It didn't expand or change the uses of the properties that were existing at the time. It didn't create any additional impact on the community. And interestingly enough, even after the 2012 division of the land and Mr. Devon is acquiring title to the property, he did not hear one complaint from Mr. Shinet or any other neighbors about the ongoing operation of his business. So it's not until the creation of a patio that this has all come to play. And I would suggest again that there's been adequate public hearing on this matter, that the parties have had an opportunity to be fully heard. They were, I would say, there was very clear indication from the licensing board that they were not quite pleased with the level of opposition that was expressed. against Mr. DeBona's efforts to expand and improve his restaurant. And mind you, not only did they create a patio, but remember, that area of land was a driveway that serviced a dumpster. So what would happen on a regular basis is that a trash truck would drive on that area. Not open space, not pristine green space as is suggested, but it was a driveway that serviced a dumpster in the rear. That dumpster has been removed. The trash is now being dealt with in a different fashion. It will not have any, so the trash and grease and other waste will not have any impact on those residential neighbors that exist today. So my suggestion is that not only is patio following the intent and the wishes of the city, but it's also cleaning and beautifying an area that was in need of some change. And as you drive by that, and you probably had a chance to drive by that, I would suggest that you would clearly see that that's an improved area. So we're disappointed that they've chosen this venue to now somehow, use this as leverage to prevent Mr. DeBona from doing some improvements to his property. But I think it's inappropriate for them to do